Again, thank you for joining us this evening. You're now attending the webinar entitled "The Bill of Rights in the 20th Century and Beyond." Our leader for this session is Sara Mayeux, Associate Professor of Law and History, Vanderbilt Law School, Vanderbilt University. I also want to give a shout out and thanks to Amanda Oswalt, who is a part and a member, active member of this year's Teacher Advisory Council, who will serve as our TA for tonight. Amanda will be active in the chat, sharing thoughts and resources and asking questions. Again, Amanda, I hope you are well. Thank you so much for joining us this evening. Sara Mayeux is a legal historian of the 20th century United States, focusing on criminal law and procedure, constitutional law, and legal culture. She is also interested broadly in the interplay between law and history. Her book, Free Justice, A History of the Public Defender in 20th Century America, was praised in The Nation magazine as a definitive history of the important yet conflicted institution and received the 2020 Langham Prize in American Legal History. The book chronicles debates about indigent criminal defense from the Progressive Era through the Cold War. Professor Mayeux earned her law degree as well as her PhD in history from Stanford University. Again, Dr. Mayeux, we are fortunate to have you with us tonight. We're honored to have you, and we're truly appreciative of the time and your willingness and your commitment, and we look forward to hearing from you.
Okay, so I think I'm unmuted, so hopefully.
Yes, you are, and you sound great. Thank you.
All right. Well, thanks so much for having me. It's always exciting to get to share with, different audiences than the law students, which is who I spend most of my days teaching our future lawyers. But of course, they're certainly not. Lawyers certainly don't have a monopoly on the Constitution or the Bill of Rights, and so it's always very exciting to get to talk about these things with teachers and professors and members of the public. And so I'm excited to be here with all of you tonight. And my topic is, as the slide says, the Bill of Rights in the 20th century. So I want to do some chronological framing just to put that in context, because I'm sure most people, if you ask them to think about the Constitution or the Bill of Rights, they might vaguely associate it more with the 18th century, with the founding of the United States in the late 1700s, and the the sort of material that we may remember, that many of you may teach in kind of a high school U.S. history class about the debates over the Constitution and the Federalists and the Anti-Federalists and things like that. So, of course, that's certainly, that is certainly a big part of the story when we're talking about the Bill of Rights, because, of course, it is in the 18th century that these first 10 amendments, which is what we usually mean today by the Bill of Rights, are the first 10 amendments to the Constitution. So the Constitution got ratified in 1789, and then there's this debate over whether it is kind of perfect the way that it is. Well, I don't think anyone thought that it was perfect, but whether it was good enough the way that it was, or whether it already needed to be amended kind of right off the bat. And so there is a series of amendments that get proposed in, right away, basically, right after the Constitution is amended. They're already in the process of trying to add to it and fix it. And the first set of amendments get ratified in 1791, so very quickly. So 2 years after the Constitution gets ratified, and therefore, the structure of the United States government that we basically still have today, with the president and the Congress and the Supreme Court, all of that is up and running. But very quickly, 2 years later, in 1791, there are 10 amendments out of the group of actually 12 that had originally been proposed. And so there are 10 amendments that get ratified in 1791, and I'm sure this is all, super familiar to anyone who's familiar with the text of the Constitution, but the first 8 of those amendments really have to do with individual rights. And so just a shorthand listing that you see on the slide goes through the First Amendment, which includes a variety of individual rights pertaining to freedom of religion, freedom of speech, freedom of the press, freedom of assembly, freedom of the ability to petition the government with grievances. The Second Amendment, of course, which is in the news quite a bit lately, is the one that contains the right to keep and bear arms, to use the 18th century terminology. And the Third Amendment is kind of obsolete for all practical purposes. Most people would say today there's not a lot of active court cases that have anything to do with the Third Amendment, but it was important at the time as a reaction against the British having forced residents in the colonies to house soldiers. And so the Third Amendment, the new United States makes this promise that the government can't force anyone to house soldiers in their house if they don't want to. Very important, and in contrast to the Third Amendment, where there's not a lot of court cases, the Fourth, Fifth, Sixth, Seventh Amendments, you could go to any courthouse around the country today on any given day, and you would hear lawyers making arguments on behalf of their clients that, for example, the police had violated their Fourth Amendment rights because they searched their car and they didn't have the appropriate level of evidence required to search their car, or they didn't have a warrant to search their house, or the Fifth Amendment has to do in part with police interrogations and the right against self-incrimination, and so et cetera, et cetera. There's this series of amendments that relate to rights that you would have if you were charged with a crime in the United States. And so all of that gets added to the Constitution in 1791, so it's been there basically almost since the founding of the United States. So why am I calling this webinar the Bill of Rights in the 20th century, and why would we have, invited me, a 20th century historian, to talk about this subject? The funny thing about the Bill of Rights is that although the text of the Bill of Rights is added to the Constitution in the 1790s, and the wording, of course, and you might think even the list of rights that are protected in their substance really reflect, concerns that people would have had in the 1790s about government overreach and freedom of speech, freedom of religion, of course, being an enormous, something that was really on people's minds in the 1790s. So the kind of substance of the amendments get into the Constitution in the late 18th century. But for all practical purposes, in the sense of rights that you can go enforce in court and that actually mean something for your everyday life, and in the way that we think about the Bill of Rights today, which is, if the government does something to me, I'm going to go complain, I might file a lawsuit, I might try to find a lawyer, I might try to make this an issue in court. There's this sense people have today that these rights are not just symbolic, and they're not just kind of aspirational statements of principle or something like that, but that they're actually legally enforceable, almost like a contract or something that you could go enforce in court. And that sense of the Bill of Rights is what I mean when I say that the Bill of Rights really, as we know it and use it today, is much more a phenomenon of the 20th century for reasons that I'm going to talk about as we go through the webinar. It's really much more a 20th century phenomenon in many ways. And the text of the 18th century doesn't really get infused with a lot of practical meaning until much later in the history of the United States. So I think in many ways, really, we should be, thinking about the Bill of Rights as something we teach when we teach modern history, when we teach 20th century history, the history of World War II, the Cold War, things like that, for reasons that I'm going to get to in more detail. But before we get to the 20th century, I do want to answer some perhaps questions that you might have, which is, okay, why was it that there was this almost, century between 1791 and say 1900 or the 20th century? What was going on with the Bill of Rights during that whole time period when I've implied that they didn't necessarily have that much practical import? And one important thing to know about the Bill of Rights is that originally the thinking was that all of these rights, the First Amendment, the Fourth Amendment, et cetera, that are in the text of the federal Constitution, actually only are rights. At the time, it was thought these are only rights that you can assert against the federal government. So if Congress or a federal court or the President of the United States or an agency of the executive branch of the United States did something that you thought was violating your rights, you could complain about it. But the original thinking was that these amendments did not have any application, and really the federal Constitution, for the most part, did not have any application to state and local government. Of course, it's true today, and it was even more true for early United States history, that people have a lot of day-to-day interactions with state and local government, much more than they do, much more than they do in many situations with the federal government, and particularly in the 18th or 19th century, people almost never would have interacted directly with the federal government. So there was not yet a federal income tax. There was a post office, so you might send something through the federal post, or I don't know, you might like run for federal office or something like that. But most of the time, if you're handling your kind of local business with your property or things like that, you'd be dealing with the state and local government. And the Bill of Rights was not originally considered to have any application to state and local government. So that's why, that's one major reason why for a long time the Bill of Rights, although it was in the federal Constitution, didn't have that much practical importance for people's day-to-day lives, as you might think. There actually was this is a little taste of what we do in law school where I teach, but there was a Supreme Court case that clarified or confirmed this early interpretation of the Bill of Rights, which is a case from the 1830s called Barron against Baltimore. So Barron, the facts of this are not that important for our purposes, but whoever Barron is, he has a complaint that he thinks the city of Baltimore, which is a unit of the state of Maryland, of course, so he has a complaint that Baltimore has violated his rights in some way. And I'm going to go back to the Bill of Rights because what he is citing is a provision of the Fifth Amendment, which has to do with due process of law and not taking people's property without complying with certain requirements and things like that. And he says, well, I think that Maryland is violating my Fifth Amendment rights. And the Supreme Court says, no, you can't do that because the Fifth Amendment is part of the federal Constitution and it's a limit on the federal government only. You cannot enforce it against the state of Maryland. So the full quotation from the opinion goes on to say that the Constitution, at least the federal Constitution, is about the federal government, the government of the United States. Each state also has its own constitution with its own state government, and they may or may not have, equivalent Bill of Rights in the state constitution, but you cannot use the federal constitution against the state government in the 19th century, or for most of the 19th century. The Supreme Court says, the assumption in the United States, even after the founding of the federal union, was that the states were pretty self-sufficient, self-governing for a lot of purposes, and that they hadn't given up that ability to kind of run their own governments in their own way by joining the federal union. And so at the time, the thinking was you don't have any individual rights against the federal government. You may have individual rights given to you by the state government, and you would have to go deal with Maryland or whatever the state is for that, but that you can't use the federal constitution to enforce an individual right against the state. So anyway, this may sound kind of technical and I don't know, kind of it's sort of a technical point, but it actually is very important for explaining why the average person for most of the early nation, for most of the early decades of the United States, would not really have very much occasion to actually go to court and use anything in the Bill of Rights, because they're probably interacting with their state and local government much more frequently than they are with the federal government. There are, of course, some exceptions to that, and some, there are some reasons why you might have to interact with the federal government, but there's not a lot of federal criminal law yet. There's not a very expansive federal bureaucracy. So you could use the Bill of Rights against the federal government, but the federal government probably isn't directly doing as much as they would be later, and you cannot use the Bill of Rights against the states. So there's just not a lot of court cases interpreting the Bill of Rights for that reason for about 100 years after the Bill of Rights is ratified. This is often surprising to my law students because they sign up for my class about the First Amendment, for example, and everyone thinks of, the First Amendment as one of the, as literally the First Amendment, right, to the Constitution. So it's been there since the very beginning. And yet we don't really read any Supreme Court cases interpreting the First Amendment. The earliest cases we read really start in the 1920s and 1930s, so not until into the 20th century. And that's not because I'm skipping over a ton of old cases. It's because that's when the major court cases start happening. So really, in terms of actual litigation, actual interpretation of what a lot of the stuff in the Bill of Rights means, it really only gets going in the late 19th, early 20th century. So that's kind of a big, the big plot line of the webinar that we're going to go through is kind of why is it that, or what happens that means that we go from a world where the Bill of Rights is basically a list of things in the federal Constitution that may have a lot of symbolic or political importance, but are not necessarily very important for or enforceable in terms of people's actual day-to-day lives. How do we get from that to the world of today, where, like I said, you could go into any courthouse anywhere in the country and you might hear lawyers just on behalf of ordinary people on any given day making arguments under the First Amendment, under the Fourth Amendment, under the Sixth Amendment, et cetera. The Bill of Rights becomes much more practically significant and much more the subject of active judicial interpretation and litigation only by the 20th century. And so kind of my goal for the rest of this webinar is to sort of explain what exactly happens. And there will be some pictures and things as we go through, so it won't all be Supreme Court opinions, although we will have to talk about a few Supreme Court opinions as we go.
And Dr. Mayeux, I will say that's great. I have a single question for you before you move into that next session, if that's appropriate, if that's okay. It's from Miguel. His question was about the Third Amendment. Would the Third be a limit on government versus a right? Are some sections of the amendments limits on government while other sections are more outlining individual rights?
Yeah, that's a good question. Although it makes me kind of want to answer it with a question, which is, I mean, I think part of how we would have to answer this is we'd have to figure out what is the is there any distinction between a limit on government, or a right? So you might think that a right basically is a limitation on government, a limit on what the government can do to individuals. So I don't know, that could be a fun topic for discussion is, what exactly do we mean by that? But I think it's true. I think what is certainly true if you read the Bill of Rights is that there are parts of, well, let me step back. If you read the original Constitution of 1789, we would say, in sort of the world of legal academia, we would say that original Constitution is almost all about what we would call structure. It's almost all about separation of powers, the branches of government, the relationship between the federal government vis-a-vis the states. So it's about sort of limits on government in the sense of what different parts of the government can and can't do, and how they relate to one another. And in contrast, everything in the Bill of Rights is usually interpreted instead as much more about rights in the sense of individual rights. But actually, there's a lot of overlap when you actually get into it. The Second Amendment actually is one that many historians of the 18th century, although which I don't pretend to be, but many experts in that early history would actually say the Second Amendment is not really about individual rights so much, but what was originally about actually a structural concern that the federal government would try to trample on the state militias. And so that you could understand the Second Amendment as also kind of about, a limit on sort of the power of the federal government vis-a-vis the state. So I guess this is not a super, I don't know, this is something we often do in law schools, and it always annoys my students, which is to kind of answer a question with more questions. But I think that the line between those two modalities of constitutional protections are actually pretty blurry. And so I think the Third Amendment probably fits in that category where, you could imagine this as an individual rights provision in the sense that if the government showed up and wanted to house soldiers at your house, you might want to go complain about that and assert an individual right not to have that happen. But it also might reflect a kind of structural limit on the relationship between military and civilian society or something like that. But there's no Supreme Court cases really interpreting the Third Amendment, so we don't really know that much about what it may or may not mean.
Yeah, it's really interesting how it dovetails right into the fourth, the search and seizure, where you hear of the discussions, obviously, the right to privacy and how that's been applied throughout the years as well. So that kind of blurs that line a little bit more too. If you will, there's one additional question from Daniel Class that I can bring your attention now. And I'll read through this first and I'll get to your question. But good evening, Professor. I'm irked by how the Ninth Amendment has been ignored or dismissed as unimportant, a la Robert Bork during his confirmation hearings. Yet it shows up in the reasoning in Roe versus Wade. On a larger level, I find it to be a perfect vehicle for classroom discussions with my students. Could you please comment on the Ninth Amendment's importance for our understanding of rights? Relatedly, there is a right to privacy as seemingly allowed by the Ninth Amendment. Do you think it's worth considering a right to disconnect from media, as some European countries are discussing? Are there any legal scholars making that argument? And again, I'll go to his first question, which is, could you please comment on the Ninth Amendment's importance for our understanding of rights?
Yeah, so I didn't put the Ninth Amendment on here, so I'm kind of part of the problem that the question identifies, which is that it is true that the Ninth Amendment has been somewhat neglected. The Ninth Amendment, just to recap, since I didn't put on the slide, but I'll remind everyone that it states that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So this idea that just because there's this list in the first 8 amendments that doesn't mean that that should be interpreted as an exhaustive list, or that people might retain other rights that aren't listed as well. There's a lot of, this actually relates to the other question, because there's a lot of debate about what that means and whether you can actually interpret the Ninth Amendment to itself provide an independent source of rights, or whether it is, intended again more as actually a structural federalism provision, meaning that it was intended to confirm that that the enumeration of rights in the federal Constitution shouldn't be interpreted as doing anything more than, enumerating certain rights against the federal government, and that that people might retain other rights from other sources of legal authority that they might enforce against, in other ways. The Supreme Court does have a lot of back and forth about the Ninth Amendment, not only in Roe v. Wade, which is the abortion case from the 1970s, but also a case called Griswold v. Connecticut in 1965, which, unlike Roe v. Wade, is still good law, which is actually about the right to birth control rather than abortion. And in Griswold v. Connecticut, there is a long back and forth between the justices about what is the relevance of the Ninth Amendment, and whether it is itself a source of, whether you can say there's some list of rights that we would put under the umbrella of the Ninth Amendment, or whether it's just an aid to construction of the Constitution more generally. The Supreme Court has never adopted the view that the Ninth Amendment, that there's a list of specific rights that fall under the Ninth Amendment that we would then come up with that you would then, for instance, go to court and have a Ninth Amendment case where you say, I have a right to do something in the Ninth Amendment. So the Supreme Court generally instead adopts the view that it's just sort of a restatement of the idea that the federal government has limited power, that the Bill of Rights lists certain rights that originally were thought to be protections only against the federal government, and that otherwise the states retain the power to do whatever the states already have the power to do. The people might retain rights, vis-a-vis the states or vis-a-vis other authorities, and that nothing in the Bill of Rights was intended to alter that sort of federalist structure. But there are other justices that have had different views about the Ninth Amendment, and so I guess I would recommend that if one finds this interesting, that in addition to Roe v. Wade, actually Griswold might be an interesting case to pull out some passages and discussion about that. But I will say that I don't know that anyone is making any more specific arguments nowadays about the Ninth Amendment, just because it is kind of a self-perpetuating. If you think that the Ninth Amendment has been unjustly neglected, I would say that you would probably be disappointed to learn that I think it continues to be neglected, mostly for better or worse, in active court litigation. So it's always been the kind of thing that's academically debated quite a bit, but doesn't become part of this 20th century history of sort of really robust litigation in the way that the First Amendment does, or that the Fourth Amendment does, for example.
Good deal. Thank you so much.
All right. So to kind of loop back to where we were, I wanted to just give you 3 big picture historical changes that had to happen in order to transform the Bill of Rights, like I said, from this somewhat limited list of rights that are somewhat more, that have pretty limited application for most of the 19th century, into what they become later, which is actually very important rights that people use in their day-to-day lives and can use in their day-to-day lives in a much more robust way. So the first big change is that the Supreme Court ultimately actually reverses its earlier view, and over time, the Supreme Court decides that, actually, the Bill of Rights does directly apply to the states, to state government and local government. That it's not, in fact, only a limitation on the federal government. And that, of course, once you do that, it expands the possible universe of complaints you might have, much to a much larger set of possible cases, because, of course, again, like I said, most of the time when people are charged with a crime, for example, it's not in federal court, it's the state of California that's charging them with a crime, or the state of Massachusetts, or, Griswold versus Connecticut is a criminal case, the state of Connecticut. And so once the Supreme Court says, you can also use the Bill of Rights in those cases as well, that really opens up the possibility of a lot more active Bill of Rights litigation. So I'll talk a little bit about why that happens, and then there are 2 other more kind of contextual changes that happen, one of which is the rise of what we would call cause lawyering, which is a new model of thinking about how to be a lawyer that really comes about in the 20th century, and then also the historical context of World War II and the Cold War. Perhaps, surprisingly, but that becomes a very important backdrop for really reframing how people think about the Bill of Rights. So I'm going to try to get through each of those 3 bullet points for the remainder of the webinar and see where we are. So the first big change that happens is what we call, the technical legal term for this would be incorporation against the states, which just means that the Bill of Rights, which originally and still, of course, applies to the federal government, is also incorporated against the states, meaning the court says, well, the Bill of Rights also applies to the states because they interpret the 14th Amendment, which comes much later, as incorporating the Bill of Rights, and as therefore sort of serving as this vehicle through which everything in the Bill of Rights now also gets applied to the states. The text of the 14th Amendment, which is an amendment that is ratified in 1868, right after the Civil War, should be on this slide here, and I just want to highlight one part of that. So the 14th Amendment, I'm sure there are numerous webinars that one can attend about this amendment itself and the Civil War and Reconstruction changes to the Constitution. But for our purposes, the key thing to know is that the 14th Amendment is ratified after the Civil War. And of course, the number one concern on everyone's mind after the Civil War is that a huge destructive war was just fought over the abolition of slavery, and the concern is that slavery represented the most extreme example of state governments, which were egregiously violating the rights of individuals in all kinds of ways within those states. And so the concern after the Civil War is what new limitations on the state governments can be put into the Constitution in order to prevent the states from either reviving slavery or, trying to kind of revive slavery to, without literally reviving slavery, but sort of invading people's rights in other ways so as to resurrect a legal architecture of racial hierarchy or other unequal hierarchies in this kind of post-Civil War Reconstruction moment. So there's many different components of the 14th Amendment, and it's a very complex amendment that actually has even more parts to it than I've put up here. But the part that is important for understanding what we're talking about right now is that it says, nor shall any state deprive any person of life, liberty, or property without due process of law. The Supreme Court is going to interpret that text to mean, among other things, it means a lot of things, but one thing it means is that due process of law means compliance with the Bill of Rights. So it means that, California or Maryland or whoever is not allowed to interfere with certain parts of the Bill of Rights that are deemed so fundamental that they are essential to what it means when we talk about due process of law. So this is, again, this is a very technical workaround, but it's the way in which the Supreme Court ultimately starts applying the First Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, et cetera, not only to the federal government, but also to each of the states. This interpretation is there's a kind of extreme version of this incorporation view, which is associated with a member of the Supreme Court from the mid-20th century named Hugo Black, who had concluded that he believed that the framers of the 14th Amendment after the Civil War were concerned in part with making sure that the Bill of Rights would now have to apply to the states. And Hugo Black has this debate with his colleagues on the Supreme Court over a period of time, which is often a very heated debate. They have all these feuds. So we might think of the Supreme Court today as very politically polarized, but the Supreme Court in the 1930s and 40s, they had all kinds of personal and political disagreements as well. But one of the feuds that they were having was over this question of whether the Bill of Rights applied to the states or not. But ultimately, the Supreme Court gets pretty close to the Hugo Black position, because what they do is that one by one, there's a series of cases that apply most of the Bill of Rights to the states. I'm going to show you a chart which has a lot of text on it, and again, the details individually are kind of interesting, but the point of this is just to show you in the aggregate that over time, the Supreme Court, one by one, has a series of cases where they say, oh yeah, the right to free speech in the First Amendment, that's incorporated against the states by virtue of the 14th Amendment. The right to free exercise of religion, right? That's not only a limitation on the federal government anymore. We think that's incorporated against the states by virtue of the 14th Amendment, the Fourth Amendment, search and seizure, that doesn't only apply to the FBI and federal law enforcement, that also applies to the LAPD or the, I'm in Nashville, so the Metro Nashville Police Department, right? They have to adhere to the Fourth Amendment as well, because the Fourth Amendment is incorporated against the states by the 14th Amendment. So there's a whole series of cases, most of which are done by the 1960s. So most of the Bill of Rights has been incorporated against the states by the 1960s. The Second Amendment is an outlier, which only actually much more recently has been incorporated against the states. And, I'm happy to, if people have questions about that, that's maybe an interesting thing for Q&A, but I'm going to skip over that right now. But the thing to understand is that over time, the Supreme Court says, oh, wait a minute, we used to think the Bill of Rights was only a limit on the federal government, but we now think, given the momentous constitutional changes after the Civil War embodied in the 14th Amendment, that we need to have uniform rights throughout the country, whether it's the state or the federal government, whether you're in California or whether you're in Mississippi or wherever you are. We need to have a uniform set of individual rights. And so one by one, they take the parts of the Bill of Rights and apply them also to the state and local government. So this is actually a quote from Dobbs, the abortion opinion. And this is not a quote about abortion in that opinion. It's just a general statement of what is now a basic fact of constitutional law. So you could find similar statements just in any Supreme Court case that you might read, might just by way of summarizing, the case law generally might have a line like this where it says, the Bill of Rights originally applied only to the federal government, but this court has held that the majority of those rights are now equally applicable to the states. So that, of course, opens up an enormous amount of possibility, because now any criminal defendant or any school child who has a complaint with their local school district or something like that can frame that as a federal case, right? They can say, well, this is my right under the federal constitution that the state or the local government is violating. So in the 20th century, that's why you get a lot more, cases, and a few of those become Supreme Court cases. So you get a lot more Supreme Court cases interpreting, all of these amendments. And that's why, for example, when I teach my class about First Amendment law, all of the cases we read are from basically the 1920s, 30s onward. And most of them really are from the 1960s onward, because it's during that period in the 20th century that the Supreme Court is really infusing that language of the Constitution with a lot of actual kind of legal meaning. The second change that I mentioned, which goes hand in hand with these legal changes, is that, of course, you also need lawyers to make arguments. So even though the Supreme Court has said, okay, well, these amendments apply to the states, people need lawyers to make the specific arguments about how any particular amendment relates to their particular case. And so although there are a variety of ways in which people might try to, secure legal assistance, there's another new development in the 20th century that helps out with this, which is the invention of these organizations that still exist today, and that there are many more than I have on the slide today, but what we would call public interest law firms, or there's different ways of categorizing this, but we sometimes call these groups cause lawyers, because they are not only lawyers for individual clients, although they do have individual clients, but they also think of themselves as trying to advance some kind of social or political cause through their legal work. And so the first really significant example of that is what becomes the NAACP Legal Defense Fund. So the NAACP is founded in 1909 to advance the interests of African Americans in the United States, and then they spin off what becomes a separate organization, and it's still today a separate organization called the Legal Defense Fund, which is responsible for many of the most famous cases in U.S. history, such as Brown versus Board of Education, which I'm sure we've all heard of, but also a lot of criminal procedure cases, a lot of First Amendment cases are brought by the NAACP Legal Defense Fund. And then another organization that you probably know of today that's still around is the ACLU. And so they also are established around this time, the early 20th century, in 1920. And they originally get started to defend the rights of working people, of labor unions and the kind of labor movement, but they eventually become known for advocacy around the First Amendment and free speech, and now they've expanded, into a variety of areas even beyond that. But they really brought a lot of the most famous First Amendment free speech cases in the 20th century. And so there's this kind of symbiotic relationship where the Supreme Court is interpreting the Bill of Rights more expansively, and then the legal profession is developing these organizations that are ready to kind of push the Supreme Court to go even further and say, well, now that you've said you're open to the First Amendment applying to the states, for example, here's our, we have a lot of arguments about what we think is wrong with any particular situation. So the kind of familiar thing that we know today, where you see these pictures outside the Supreme Court with the lawyers and the activists and the protesters and stuff like that, I mean, that really all is a phenomenon, again, of the 20th century, and certainly beyond, because it's still going on, today in the 21st century. All right, so the last piece I want to add to this historical context, that's the backdrop to a lot of what I've been talking about, meaning the backdrop against which the Supreme Court in the 1940s, 50s, and 60s is having a lot of these debates, and that lawyers are arguing these cases, is the context of World War II, and then after World War II, the Cold War against the Soviet Union. So you might be thinking, like, well, I don't know, you may or you might not be thinking this, but you might be thinking, what is geopolitics or military strategy or anything like this have to do with the Bill of Rights? Well, it so happens that, of course, both, during World War II, the United States is holding itself out as leading the battle against Nazism and fascism and imperialism and dictatorial rule. And then during the Cold War, it's going to hold itself out again as representing the promise of democracy in contrast to communism. And the one way in which the United States is going to contrast democracy with communism is to emphasize that in the United States, there are these individual rights that are protected in the Constitution, and they're not just protected in theory, but that, there are actual court cases in which people can assert their rights against the government. So during World War II, and then the years right after World War II, in the kind of early Cold War moment, there's this real series of celebrations, kind of civic celebration, commemoration of the Bill of Rights. So this is so they actually send the Bill of Rights around the country on a train, on this famous exhibit called the Freedom Train, so people can look at it and think about it in 1948. So that's what this picture is showing you, is this idea that, not only do we have litigation about the Bill of Rights, but we literally need to send it around the country so people can really ponder what it means for them. Franklin Roosevelt proclaims Bill of Rights Day on what was the kind of an important anniversary of the ratification of the Bill of Rights. And so that's what you see in this image is, the president signing this official proclamation that everyone needs to celebrate the Bill of Rights. And you see a lot of propaganda posters along this line that the United States is fighting the Nazis in order to protect, in part, the idea of individual rights, of the Constitution, of the Bill of Rights, and things like that. So when the Supreme Court is interpreting the Bill of Rights more expansively, it's not doing that in a vacuum, but it's doing it against this broader political celebration of individual rights as a distinctive piece of what it means to live in a democracy. And then after World War II, when you transition into the Cold War decades against the Soviet Union, this theme continues with presidential rhetoric. For example, Harry Truman, who's speaking to a bunch of law enforcement officials in 1950, he says, it would be a lot easier for all of you to catch criminals if we did not have a Bill of Rights, because the Bill of Rights gives individuals all of these, protections against the police and against prosecutors and things like that. But the Bill of Rights is what distinguishes the United States from the totalitarian powers, meaning, of course, the Soviet Union and other communist countries at the time. And so this all just fits this theme that, again, that against this backdrop, that's partly, I would argue, what's going on when the Supreme Court is in the judicial branch, kind of more expansively interpreting the Bill of Rights in the 20th century. The other branches of government are also encouraging a kind of political celebration of the Bill of Rights as well. All right, so maybe we'll end on just one example out of the many landmark cases that come out of this 20th century kind of efflorescence of individual rights litigation, and one that might be, I think of particular interest to students is a case called West Virginia versus Barnett, which is right in the midst of this World War II moment in 1943. So the United States is fighting World War II, as this case is being decided. And the case has to do with children who are members of the Jehovah's Witnesses. And so as a result, their faith teaches them that they're not supposed to pledge allegiance to the flag or to any what they consider a false idol. And so they opt out. They seek, they go to public school in there are cases from both Pennsylvania and West Virginia, but they go to public school where at the time everyone had to say the Pledge of Allegiance every day, and they say, well, we can't pledge allegiance because of our religion, and they actually got expelled from school. And the Supreme Court in this very important case says that, in fact, the schools do not have the power to punish them, that, in fact, every student has a First Amendment right not to pledge allegiance if they don't want to pledge allegiance. And it's a really remarkable case because the opinion is quite remarkable, because if you think about this as happening really at the height of World War II, and there's a very, there's an even deeper backstory to this about popular ostracism and violence against Jehovah's Witnesses, who were seen as not being appropriately patriotic and kind of unified behind the country at a moment when the United States has soldiers fighting all around the world. And the Supreme Court says that, in part, what those soldiers are fighting for, as the Supreme Court puts it, is the individual right of people not to pledge allegiance to the flag if they don't want to. And so it's this very important early interpretation, actually, of students even having certain free speech rights, even in the context of the school, which, of course, otherwise schools have all kinds of rules. It's kind of seen as an institution that couldn't operate without some kind of rules, but the Supreme Court says that there are certain limits to that. And so the very famous language from West Virginia versus Barnett that you see actually talks not only about the First Amendment specifically, but also the Bill of Rights more generally. And Justice Jackson, who's the Supreme Court justice who writes this opinion, says, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship, and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. So I want to highlight two things about this quote, which really encapsulates the 20th century interpretation of the Bill of Rights, which is one, that it is what we would call a counter-majoritarian document, right? That most of our system of government in the United States operates on majority rule, and we have elections to decide who's going to be the president or the mayor or whatever. But if you had an election and asked people, should school children be punished if they don't want to pledge allegiance at the height of World War II, the majority of people would probably say that they agree with the school, that the children should have pledged allegiance. And so the point of the Bill of Rights, the court says, is that there are some protections that have to be given to individuals against the majority. That's the kind of whole meaning, the way they're conceptualizing it, of what a right is it's a right to protect what might be a minority viewpoint or a minority group or a minority view, and that you can't have an election about it, right? It can't be protected through voting or through elections, because by definition, the majority is not going to protect minorities during elections. So instead, this is the second point about this quote, who's going to enforce those protections for people who are outsiders in their community? It has to be the courts. So this just underlines this theme, which is that over time, the Bill of Rights goes from text in the Constitution to legally enforceable rules that are laid out in case law interpreting that constitutional text, and then that you can then use as legal principles to be applied by the courts. And so if that's what we think of when we think of the Bill of Rights, that is not really an 18th century phenomenon. It's much more a 20th century phenomenon, and it required not only changes to the Constitution and to the Supreme Court and to interpretation of the Constitution, but also this context of World War II and the Cold War, which provides this context within which the significance of individual rights in a democracy is really brought into relief or highlighted for not just lawyers and judges, but also everyday Americans. So I might kind of take a moment there, and I don't know if there are any questions.
Thank you. There is one question that we have from John. His question is he mentions that standard textbooks regularly support the notion that the Supreme Court is non-political. This is not the case. If you were a high school teacher, what would be a top choice legal case study to introduce Supreme Court partisanship? I hope this question does not seem too silly, John says. But if you were a high school teacher, what would be a top choice legal case study to introduce Supreme Court partisanship?
Well, it's definitely not a silly question. I think it's a question we think about when teaching law students as well, because, I actually think it's not really just textbooks. The Supreme Court currently, the justices of the Supreme Court themselves, in recent years, have made a real effort to present the court as non-political. And I think it's because they are frustrated by what they perceive as, I think, public sentiment that, oh, these are just politicians in robes, or, they're not doing anything different from politics. And if you think that they're not doing, then it raises all these questions about, well, like, what is supposed to be the distinction between law and politics? So one thing I would say, which I think would work okay for students, high school students, is that you can find all of these speeches in recent years in which, and it's not any particular, it's from all over the Supreme Court in a political sense. So whether it's Sonia Sotomayor, who we think of as very liberal, or whether it's Amy Coney Barrett, who we think of as pretty conservative, they've all given these speeches in the past few years where they are really taking pains to try to say, like, we're not politicians, we're judges, and we're doing something that's not political. So it might just be interesting to have students discuss whether they agree with that or whether they don't agree with that. But in terms of, historical cases, I would say that this current preoccupation with trying to present the Supreme Court as non-political is actually, I think, a more recent phenomenon than we might realize in some ways, because for a long time, the Supreme Court was, it was not seen as political in the sense of partisan necessarily, because the justices' votes on the Supreme Court didn't necessarily line up with Democrats or Republicans in the way that you might think that they do today. But it was always very political in a different way, which is that historically most of the justices had prior experience as politicians. So Hugo Black, who I will go back to show you, so he was appointed by Roosevelt to the Supreme Court, but he had previously been a member of Congress. And Earl Warren, the very famous Chief Justice of the Warren Court, of course, had been the governor of California. There's a justice called Abe Fortas who actually gets into a lot of trouble in the late 60s and kind of has to leave the court in scandal, but he was basically just a political crony friend, like a political friend of President Lyndon Johnson, who got on the court for that reason. So the court used to be, I think, political in a more open way, in the sense that, the members of the court were people who had previously been politicians, and people might have heard of them before they got on the Supreme Court because they knew of them as politicians. And so there wasn't, I think, therefore, the Supreme Court, in a lot of these Warren Court cases especially, they felt kind of free to write opinions that were framed as, this is what I think is the best solution to this problem. And they weren't necessarily trying to deny that there was a policymaking dimension to what they were doing. I think what we've seen is that the Supreme Court today, whether Democrats or Republicans, everyone that gets appointed to the Supreme Court today is usually just someone who has either academic or judicial experience. It's much more unusual. There's no one on the court today that ever had an elected political office before they were on the Supreme Court. So in a weird sense, I think that might explain why they get so offended when people call them politicians, because they think like, oh, politicians are those corrupt people that make deals and run for office and have to cater to their donors. And, we don't do any of that. We're just, we're just lawyers. We're just judges. And so they have this real investment in sort of, presenting themselves as not, as not politicians in a way that I think many people don't find very plausible, but I think it might be explained in part by just those shifts in kind of who's getting appointed to the court. But I think, in terms of cases that, like a particular case that might be interesting to talk about, there are these cases from the Warren Court about voting rights And so one important case is called Baker versus Carr. And then there's a case called, what is the other case called? Let me see. So there's a case called Baker versus Carr, and then there's a case called Reynolds versus Sims, anyway, these cases are about voting rights, but the reason why you might find them interesting is because those cases are literally about, in a much more kind of concrete way, this question of like, what is the distinction between law and politics, and are there certain legal issues that should be deemed as political in the sense that it's not appropriate for the Supreme Court to get involved. But when they talk about political, they mean like literally, you know, how involved should the Supreme Court be in regulating voting and redistricting and things like that. I assume what the question is in part reflecting is a sense that the Supreme Court in a variety of areas is, you know, deciding legal questions that relate to issues of intense political debate like abortion or contraception or criminal justice or policing or things like that. And so in that sense, there's, you know, in that sense, even when they're deciding very, you know, even when they're deciding legal questions, the legal questions interact with issues that many people might think are just inescapably political, in the sense that people have differences of opinion about how those issues should be resolved. And so, you know, I think in a way there's no sort of, this has been a debate, I think, throughout the history of the United States in different contexts, which is there a distinction between law and politics? Why should there be a distinction between law and politics? Is it possible to really separate law from politics in the way that, you know, the textbook narrative might say that it is or imply that it is? But I think these are good questions to discuss with students. I don't think there's any exactly correct answer, because this is obviously something that itself has been the subject of political debate. But I will say that, you know, in a weird way, the Supreme Court itself in recent years seems to have the most investment in really presenting itself as separate from politics. And so it might just be interesting to even talk to students about, like, why is that? Why don't they want people to see them as politicians? You know, what does that tell us about the way that people think about politicians today? I mean, that might be an interesting thing to talk about.
Good deal. Thanks for your response. That was a great question. We have about 15 more minutes. And if there are any additional questions, teachers, feel free to enter it in the managed Q&A box. But we'll continue on. Thank you so much.
Okay. Yeah. So just to recap where we are, as I said, the Bill of Rights at the beginning is a list of amendments that get added to the federal Constitution in the 18th century, but it's only in the 20th century that a lot of those rights get interpreted expansively to serve as kind of operative limits on state and local government in ways that matter a lot for ordinary people's lives. And so West Virginia versus Barnett is a key First Amendment case in that history. But there's also a whole series of cases, of course, in the realm of criminal procedure, which happened a little later in the 1960s, but still in this long Cold War period. And those include Miranda, which gives us the very famous Miranda warnings that the police have to give to suspects before they can interrogate them. But also, for example, Gideon versus Wainwright, which is what my book deals with, which is a case that holds that criminal defendants have to be provided with a lawyer as part of the right to counsel that the Sixth Amendment provides. And so that has a lot to do with why criminal defendants are entitled to public defenders if they can't afford to hire their own counsel. But those cases are all part of this long process of taking the Bill of Rights, applying it to the states, and then also kind of interpreting those rights in more expansive ways in the 20th century than they had been earlier. So, those cases, of course, get a lot of news coverage and a lot of attention at the time, but remain very important today. And people, can probably recite the Miranda warnings today if you watch a lot of television. But that also comes out of this kind of 20th century process of constitutional litigation. I did want to end with some suggested reading, and these are, books by other scholars or other writers besides myself that might be of interest. So I will highlight, so the first book I put on this list is actually not about anything I talked about today, but if you are curious about going back to that founding 18th century moment, because that's what is really interesting to you about the Constitution, Pauline Mayeux's book Ratification is a really in-depth, deep dive into the debates about ratifying the Constitution and the kind of context that ultimately helps to explain why they also then decide that the Constitution needs some amendments right away. But that's, of course, the earlier history that I didn't really talk about much today, but I thought I'd put it on there in case that is something you're curious about. A book that I do recommend that really I learned a lot from is a book by Gerard Maglioka, who's a law professor, who wrote this book called The Heart of the Constitution. And that goes through some of the history that I described, as well as other, it goes into other episodes that I didn't go into as much, but this kind of phenomenon of how people actually even come to use this term, the Bill of Rights, and, why does Roosevelt, for example, declare Bill of Rights Day at the height of World War II, and that sort of broader cultural and political context. And then I thought I'd put two other recommendations on the list, which are both by Anthony Lewis, who's now passed away, but for a long time he covered the Supreme Court for the New York Times during this whole time period we're talking about, the 60s and 70s and 80s, and a little later than the time period we're talking about, but during the 1960s he was like the beat reporter at the New York Times covering the Supreme Court, and then he became a columnist, and then he wrote books and all this stuff. So he wrote this book at the time in the 1960s called Gideon's Trumpet, which is about one of the cases I mentioned, Gideon versus Wainwright. And he also, much later in his life, in 2008, published a book that's a history of the First Amendment called Freedom for the Thought That We Hate, a biography of the First Amendment. And both of those books are, I think, books that advanced high school students could read and benefit from if they're, kind of advanced readers, because he was writing for a pretty general popular audience. So whether the book or excerpts of the book, but certainly teachers and professors, I think, also can find a lot of useful anecdotes and cases to talk about and historical backstory in those books that I use sometimes in my teaching, but that also might be useful for you if you're curious about, more of the specific history about any specific amendment. I would recommend those two on the list. And it looks like, so I have to thank the center for, I guess, adding a plug for for my book, which is about the public defender, which is, the lawyers that represent criminal defendants. And, my book is definitely an academic book. So I don't know that, well, I don't know. Who knows? There might be some high school students that might like to read it, but it's definitely not written for a general audience so much as for a scholarly or academic audience. But I have a chapter in that book where I go into more detail about the significance of the Cold War as a piece of background context explaining why, in particular, the rights of criminal defendants became a particular concern in the 1960s. So I think I'll wrap up there, and I don't know if there are any final questions or thoughts.
Oh, good deal. Well, thank you so very much, Dr. Mayeux, for joining us, for leading us, and sharing your expertise with us. We truly enjoyed this. Our teachers are constantly grappling with these questions, and you've given them so many approaches to approaching the Constitution in a dynamic way, and understanding this never-ending process of constitutional debate, litigation, and change, particularly with the emphasis on the 20th century, which is often overlooked, particularly with classroom teachers who are struggling with the 18th century and the formation of the new republic. And so, but thank you.
I know there's a lot of constraints on curriculum and things like that, but I will say that, to the extent that you can jump ahead to the 20th century, I think students often find that context really helpful for relating the Constitution to their lives. And so I definitely recommend bringing that in as much as you can.
Absolutely. Well, again, thank you very much. And to everyone who's here tonight, I encourage you all to keep up with what's happening at the National Humanities Center through our various social media feeds, channels, networks, to get updates on our activities. I'd also invite you to check out our next webinar, which is scheduled for Thursday. Mao and the Chinese Cultural Revolution. We have Andrew G. Walder from Stanford University, and the topic is Mao and the Chinese Cultural Revolution. We will be back same time to greet you, to interact with you, to learn from you all. Special shout out and thanks to Amanda Oswald for the work that she did within the chat, as well as the work that she's doing on our Teacher Advisory Council. There's so many familiar names that I'm seeing from week to week, and I can't say enough how much we appreciate the energy that you bring to the chat, the sense of community, and the names Cedinia and Andrea, Nancy, everyone. We welcome you back, and as I've said numerous times before, we appreciate all that you are doing. I am a former classroom teacher. My wife is a current classroom teacher. And we truly appreciate all that you are doing for the students, for your districts, as well as your community. So I will see you soon. Continue to do great things, and you all have a great week.